You get a call. A relative has passed away and they've left you something in their will. Maybe it's a nice round number like $50,000. Maybe it's a piece of their entire estate. Your mind, of course, starts racing. You could finally make a down payment on a home, get rid of your student loans, or book that trip you've been putting off forever. It feels like you've just won the lottery. But before you start Zillow surfing or packing your bags, I want you to just take a breath and listen. There's a critical and honestly widely misunderstood truth about how inheritance actually works. That number written in the will, it's not a guarantee. Think of it more like a reservation at an exclusive restaurant. Your name is on the list, but you can only be seated after a long line of other VIP guests. The lawyers, the government, the lenders have all been served first. Today, we're going to pull back the curtain on what really happens to a person's assets after they die and show you exactly why your inheritance might be a lot less than you think. Section 1. The estate is not a treasure chest. When you hear the word estate, you might picture a sprawling mansion on a hill. But in legal terms, an estate is just the financial backpack a person leaves behind. We're talking about their house, car, bank accounts, investments, furniture, even the weird collection of vintage lunch boxes. It gets all bundled together into this backpack. Now here's the key. Don't think of the estate as a treasure chest just waiting to be unlocked. It's more like a small business that has suddenly closed its doors for good. Before the new owners, in this case you and the other beneficiaries, can take home any profit, the business has to pay all its final bills. It has to pay the landlord, settle up with all of its suppliers, pay its final taxes, and clear every last IOU. Only the money left in the cash register after all that is paid can be inherited. This is the part of the process that trips people up and leads to a ton of confusion and disappointment. Section 2, the starting gun, probate and the executor. The whole journey of settling an estate kicks off with a legal process called probate. It's like the official starting line for this marathon. Once a person passes away, their will has to be filed with the local probate court, which fires the starting gun. The court's main job is to confirm that the will is valid and to formally appoint the person named as the executor. The executor is the captain of this ship. It's the person, or sometimes an institution like a bank, who is legally in charge of managing this whole process. Once the court gives them the thumbs up, their first job is to notify all the beneficiaries that the will is now in probate. As a beneficiary, you have a right to get a copy of that will so you can see for yourself what the plan was. And this is where you need to get comfortable with being patient. The probate process is not a speedboat, it's a cargo ship. It's built to be steady, not fast, to make sure every I is dotted and every T is crossed legally. This means from the moment that will is filed, you could be looking at a year, or in really complicated cases, even years, before a single dollar is distributed. Section 3, the executor's massive to-do list. Let's be clear. Being an executor is a tough, often thankless job. This person has a mountain of work to do, all while dealing with the emotional weight of a loss. Their one and only legal duty is to act as a fiduciary for the estate. Think of them like a referee in a championship game. Their loyalty isn't to one team or the other. Not to you, not to the creditors, but to the rules of the game itself, which is the law. First, they have to go on a financial archaeological dig to find and gather up every single asset. This is a huge job. It means locating every bank account, tracking down investment statements, finding life insurance policies, and making a detailed list of all the personal belongings. Next, everything has to be professionally appraised to put an official price tag on it. establishing its fair market value at the time of death. This is super important for two reasons. It makes sure that when things are eventually split up, it's done fairly, and it's needed to calculate any taxes the state might owe. And here's the part that matters most to you. The executor is legally required to find and pay all of the estate's debts and expenses. They have to do this before you get anything. Section 4. Who gets paid first? The pecking order. So, how does the executor decide who to pay? It's not random. Think of the state's money like a buffet. Before the main guests, the beneficiaries can't even look at the food. A whole line of people with special passes gets to go first. This pecking order can vary a little from state to state, but the general lineup is pretty much the same. At the very front of the buffet line are the administrative expenses. This is the cost of running the event itself, the court fees, the lawyer who planned it, the executor who's managing it, and the appraisers. They get paid first. Next up, the funeral and burial expenses. The costs for the decedent's final arrangements are a high priority debt. Then comes the federal government. You know the saying about death and taxes? Well, here's where they meet. This includes the person's final income tax return and, for a very large estate, federal estate tax. It is worth noting that the law that raised the federal estate tax exemption, the Tax Cuts and Jobs Acts of 2017, is scheduled to expire at the end of 2025. For deaths in 2026 and beyond, the exemption amount is set to be reduced by about half, meaning more estates could be subject to this tax. After the feds, it's the state's turn. This covers state income tax, property taxes, and anything else owed to state agencies. Following that are medical expenses from the person's final illness. This can be a big one and can take a huge portion of the buffet. And finally, way at the back of the line are general creditors. This is where credit card companies, personal loans, and old utility bills get paid. Only after every single one of these groups has filled their plate, starting from the top, can the executor finally turn their attention to the beneficiaries. Section 5, the Great Divide, probate versus non-probated assets. You might be wondering, does every single thing my relative owned get put on the buffet table for the creditors? And the answer, surprisingly, is no. This is maybe one of the most important things for a beneficiary to understand. Assets fall into two buckets: probate assets and non-probate assets. Probate assets are the things owned only in the deceased person's name. This is a general admission ticket to the probate process. This is the food on the buffet table that has to be used to pay all those debts we just talked about. But non-probate assets are a different beast entirely. Think of them as having a VIP backstage pass that lets them skip the buffet line of creditors and the whole probate process altogether. These assets pass directly to a specific person who was named ahead of time. The most common examples are life insurance policies. The payout goes straight to the beneficiary named in the policy. Retirement accounts. Money in a 401 or an IRA also goes directly to the named beneficiaries. Assets in a trust. Anything held in a living trust is controlled by the trustee's rules, not the will. Jointly owned property. A house or bank account owned as joint tenants with rights of survivorship automatically belongs to the surviving owner. Payable on death, POD, or transferred on death, TOD, accounts. These are a bank or investment accounts where the owner already named someone to get the money when they die. This is a huge deal. If you are named the beneficiary on a life insurance policy, that money's yours. It doesn't become part of the probate estate. And because it has that VIP pass, the state's creditors can't touch it. Section 6. When the well runs dry, the insolvent estate. This leads to a question that gives a lot of people anxiety. What happens if the debts are bigger than the probate assets? What if someone passes away with $100,000 worth of assets but owes $150,000 in medical bills, taxes, and loans? This is what's known as an insolvent estate. In that situation, the executor pays the bills according to that priority list until the money is gone. It's like a sinking ship. Once the ship is underwater, it can't take on more cargo. Once that $100,000 is used up, that's it. The creditors at the bottom of the list might get only a fraction of what they're owed, or maybe nothing at all. Now listen closely, because this is one of the biggest financial myths out there. Think of it this way. If a restaurant you have a reservation goes out of business, you don't have to pay its debts. You just don't get a meal. It's the same here. As a beneficiary, you are almost never personally on the hook for the deceased debts. If the estate runs dry, the debt doesn't just transfer to you. Creditors can come after your personal bank account or your house to pay your relative's bill. Creditors can't. You don't inherit debt, but the debt can, and often does, inherit the estate. Section 7, the final step. What's actually left for you? So after the executor has dealt with the court, tracked down every asset, and paid every last bill from the probated estate, what happens? Imagine the estate is a large river of assets. As the river flows along, the executor must act like a dam operator, diverting parts of the streams to pay all these different debts and expenses in the right order. Whatever is left over is what finally reaches your downstream. The executor will follow the will's instructions, paying out any gifts first, like the $10,000 to my nephew, and then dividing whatever is left among the main beneficiaries. If the river got a lot smaller after paying debts, there might not be enough water to fill those reservoirs. And it's possible the flow could dry up completely before it gets to the main beneficiaries. Once the executor is ready to distribute what's left, they'll transfer the assets to you. You'll likely have to sign a receipt confirming you got your share. The entire ordeal, from the first phone call to finally receiving your inheritance, can be long and emotionally draining. The best thing you can do is stay in touch with the executor and try to understand all the steps involved to keep your expectations in check. Let's circle back to the first phone call, that moment of shock and excitement when you found out you were in a will. While that news is a truly meaningful final gesture from your loved ones, it's not a check in the mail. It's the start of a very long, very complicated legal process. Your inheritance isn't the number written on a piece of paper. It's what's left after all the financial loose ends of a person's life have been tied up. The debts and taxes always get paid first. But remember, the weight of that debt lands on the estate, not you. Understanding how this really works can save you a lot of stress and help you set realistic expectations during a tough time. It's a sobering truth, but it's one you need to know. If you found this breakdown helpful, do us a favor and hit that subscribe button and turn on notifications. We're all about making these complex topics simple and clear. And if you've been through this, either as a beneficiary or an executor, share your story or ask a question in the comments. Your experience could be a huge help to someone else just starting this journey. Thanks for watching.